Okay. All right. Good afternoon, everyone. Good morning. My name is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the 2020 Harlan Institute-Ashbrook Virtual Supreme Court competition. This is the 10th annual contest, and I'm so happy to be here back in person. This year, our tournament focuses on the case of New York State Rifle and Pistol Association versus Bruin, a Second Amendment case pending before the Supreme Court. This competition began on the first Monday in October of 2021. More than 30 teams from across the country submitted briefs and made oral presentations. In early February, we held 13 semifinal matches. 2 weeks ago, we held a round of 8. And in March, we hosted the Final Four. After a rigorous process, the finalists were selected. Now, after 2 years on Zoom, we are honored to be back here in person at the Georgetown Supreme Court Institute. My thanks to Herb Goldstein, Debbie Traeger, and Cal Gold for hosting us here at Georgetown. It's very good to be back here in person. Now it's my honor to introduce the finalists. Representing the petitioners will be Campbell Collins and Gabrielle. These students are from Austin, Texas, and they're from a whole school. And representing the respondents will be Arjun Kishore and McClure Orlovsky from Greenwich High School in Connecticut. The format for the competition will be familiar. Petitioners have 10 minutes to present arguments. Respondents have 15 minutes to present arguments. And petitioners have 5 minutes of rebuttal. And I'm happy to introduce the judges on our bench. Presiding will be the Honorable Naomi Rao of the U.S. Court of Appeals for the D.C. Circuit. And some time ago, Judge Rao was my law professor at George Mason. The second member of the panel will be Judge Gregory Madge from the U.S. Court of Appeals for the Armed Forces. And the third member of the panel, beaming in by Zoom, will be Judge Stephen Schwartz from the U.S. Court of Federal Claims. And I'll give you a warning, this panel will be very hot, as they say. And without further ado, let's begin. I'll call the court to session. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention. The court is now sitting. God save the United States and this honorable court.
New York State Rifle and Pistol Association. We'll now hear from the petitioners.
Shall we begin?
Yes, please.
Madam Chief Justice, Associate Justices, and may it please the Court. My name is Gabrielle, and along with my co-counsel Campbell Collins, I represent the petitioners, New York State Rifle and Pistol Association, Robert Nash, and Brendan Koch. The state of New York has denied petitioners' applications for concealed carry licenses under the proper cause section of the Sullivan Act. This is unconstitutional.
Would the court benefit from a brief statement of the facts?
Certainly.
Robert Nash and Brendan Koch both applied for unrestricted concealed carry licenses in the state of New York, but both of their applications were denied due to the proper cause requirement of the New York statute, which is not defined in the statute, but in associated case law, it has been defined to mean that citizens must demonstrate a need for self-defense distinguishable from that of the general public in order to receive a license.
The question presented
Well,
today.
on that point, it's clear that your client cannot make that show that your client does not have a need other than the need of the general public.
No, Your Honor. So because citizens are required to demonstrate an extraordinary and not an ordinary need for self-defense, this law is unconstitutional because, as this court wrote in Heller, the phrase "the people" in the Second Amendment refers to all people, not an unspecified subset of the population. And the New York statute narrows Second Amendment protections to an unspecified subset of the population who has that extraordinary need for self-defense.
The way the New York law works is takes our right that has a few exceptions but is offered to all the people and turns it into a privilege that you have to earn by showing that you're special in some way, specifically that you have a special sort of danger. But our rights are not limited to people who have a special sort of danger. Now, because this New York law takes the right to carry guns from the general public and therefore infringes on that core right of self-defense, we have to look at this law under strict scrutiny.
And strict scrutiny requires two things. First, the state bears the burden to demonstrate that this law achieves a compelling state interest. And second, the state has to demonstrate that it uses the most necessary and narrowly tailored means possible to achieve that interest.
Talk, in your brief, you mentioned that bear in the Second Amendment means something different than keep. So if I accept that distinction, why that bear means to carry outside the home, why would it have to include concealed carry and not just, for instance, open carry?
Well, Your Honor, it doesn't necessarily include a right specifically to concealed carry, but the history of the right to carry laws in the United States indicate that it does include a right to carry in some format. So because citizens in New York are banned from open carry, New York has stated that that is not allowed. That leaves the only path that they can carry to be concealed. And because ordinary citizens cannot carry in New York, that's what makes this law unconstitutional.
When we go back to the strict scrutiny standard, I agree that the Second Amendment is a constitutional right, and I agree that this infringes on it, but we don't apply strict scrutiny to every regulation of a fundamental right. So, for example, we apply strict scrutiny in the First Amendment if we have a content-based restriction on speech. Well, we don't apply strict scrutiny if we have a time, place, and manner restriction on free speech. So, for example, you can't have a loudspeaker in the middle of the night in a residential neighborhood. Why isn't this more like a time, place, and manner restriction on your right to keep and bear arms, which would be subject to reasonableness rather than strict scrutiny?
The New York law infringes on the core right of self-defense, and Heller decided that it was the core right. Time, manner, and place restrictions are more peripheral matters to the right. They would be similar in this case to regulating what type of gun you can use or what type of ammunition you can use. This law infringes on the core of the Second Amendment in the way content-based restrictions on speech infringe on the core of the First Amendment.
So how would you define that core? What do you define as being the core of the Second Amendment right?
Heller has told us that the core of the Second Amendment right is being able to keep and bear arms for self-defense.
And specifically, Heller dealt with the keep prong of the Second Amendment, but because keep and bear are placed on equal footing within the text, that means that bear is also included within that core. There are accessory Second Amendment rights like the ability to carry semi-automatic weapons or the ability to carry certain types of ammunition, and those would fall under intermediate scrutiny. But because New York prevents citizens from carrying these weapons, and specifically carrying handguns at all, that is why this infringes on the core constitutional right and implicates strict scrutiny.
Can you respond to the respondent's argument about self-defense, which is, well, wait a minute. If what you're saying is you need to carry guns for self-defense, but we live in an area where we have police and we have statistics that show that it's generally safe to be about and that the police can take care of us and the government can provide for protection, to what extent do we have to take into account the real need for self-defense as opposed to merely just your client's perception that they would like to have their own form of self-defense?
You never need to have a special need to exercise your constitutional rights. We don't let you have freedom of speech because you have a specific need to say something, and you don't get your Second Amendment rights because you have a special need for self-defense. The right belongs to the people because a need for self-defense can't be predicted and can arise at any moment.
Additionally, how does that intersect with laws that, for instance, prohibit firearms to people who are mentally ill or who have other conditions? How does your view intersect with that?
Well, Your Honor, those operate from the opposite direction. New York has stated with this gun regulation that all citizens do not have a right to self-defense until it is granted back to them, until they have justified it based on their need. However, restrictions on specific small groups of people, such as felons or the mentally ill, to carry weapons operates from the opposite assumption that everyone has a right, but it can be limited in certain circumstances.
Aren't those people also part of the people in the Second Amendment?
Yes, Your Honor. However, there are certain ways that you can lose a Second Amendment right, but you do not have to earn a Second Amendment right. So because they operate from the opposite direction, because they don't turn a right into a privilege, they are constitutional. And additionally, they would likely pass strict scrutiny, which this law does not.
Counsel, can we go back to your previous argument about keep and bear being on the same footing? You know, looking at Heller, Heller only decided the keep issue, and there was a lot of historical sources that were cited by Heller on the keeping issue. And I'm just wondering, does that decision really help you on saying that keep and bear are on the same footing? Because after all, when we decided that case, we didn't really decide it for both keep and bear. We focused on keep, suggesting to me that, you know, maybe we have to look at separate kinds of historical data and information on the bear issue.
The focus was on keep and Heller, but it didn't ignore bear, and it did specifically say that they are on the same footing. Furthermore, when we look at the Second Amendment, we see the Preparatory Clause and the Operative Clause. The Operative Clause contains our right to keep and bear arms, and it doesn't treat keep and bear differently. It's not the right to keep arms and sometimes bear them. It's the right to keep and bear them.
Additionally, Heller looked at historical precedent and indicated that the Second Amendment right is drawn from English historical precedent, including the English Bill of Rights, which protected the right of English Protestant citizens specifically to carry weapons for self-defense. So that right was extended to all different religions with the Second Amendment, but that same tradition of being able to bear arms is present in the historical sources that we do have.
Can I ask you a hypothetical? Could, for example, this court pass a rule that prohibited litigants from bringing weapons into court during court session? For example, I don't know if any of you are armed, but maybe we don't want the litigants sort of chills the bench a little bit. Even the counsel have guns. Would it be constitutional for us to just simply say, unless you've got a need, you can't bring a gun into a courtroom?
That seems like it likely could fall under a sensitive place restriction, and sensitive places are specific locations where no one, regardless of your license status, may bring a gun.
Well, we certainly have police officers in the courts, and they have guns.
Yes, Your Honor, police officers in sensitive places are treated a little bit differently than an average citizen. And Heller has decided sensitive places are legal. But the difference between a sensitive place law and this law is that it is a specific location where no one can bring a gun, rather than turning giving a person individualized sensitive places. For example, one petitioner may carry his gun on the road to his workplace, while the other cannot. That makes that particular road a sensitive place for one of those petitioners, but not the other. So while sensitive places are legal, it's not legal to make individualized sensitive places.
Because those types of individualized sensitive places create, in fact, sensitive people, which is unconstitutional because, as the court found in Heller, the Second Amendment applies to all people, not an unspecified subset.
I see we are out of time.
I have one other question, and perhaps Justice Schwartz has one as well. But I'm wondering if your argument would allow any type of gun licensing. Under your reasoning, would it be permissible for a state to require licensing at all for
Absolutely.
handguns? Because that is a kind of, if you were to analogize to the First Amendment context, it is a kind of prior restraint, right? It restrains your ability to keep and bear arms if you have to seek a license. And so I'm wondering if your logic would prevent state licensing of firearms.
State licensing would not be prevented under this law, or under our position. What would be prevented is shall issue state licensing regimes. We need may issue, and I have that backwards. We need may issue.
We have may issue in the state of New York, but shall issue is only constitutional for two reasons. First, because the statute in New York allows too much discretion of licensing officers. They are in control of who receives a weapon. And additionally, because the statute has that proper cause requirement that requires a need, which is still unconstitutional because it prevents ordinary citizens from receiving a gun license.
Citizens should be able to look at how to get a license and see if they meet the requirements or have the ability to meet the requirements. Such as, okay, I don't have a mental illness, I'm not a felon, but I have to take a training course to get this gun license.
And Heller recognized that preventing states from banning certain types of weapons is unconstitutional, but that does still leave many licensing options for those states.
Let me see if Justice Schwartz has any questions.
Oh, thank you, Madam Chief Justice. I've got, I think, 3 specific questions that weren't covered as far as I could hear by your questions. So one is about the historical context. Counsel, you've done a good job talking about some of the history that's relevant to the Second Amendment, but you didn't mention this 1836 Massachusetts statute that respondent says required, quote, reasonable cause to fear assault or other injury, et cetera, as a condition for bearing arms. How do you get around that as a historical precedent for requiring some kind of individualized concern before you can exercise the Second Amendment right?
Well, Your Honor, those laws were different from this law. First of all, we have to look at what types of guns were allowed at that time. Second, we have to look at what were the types of self-defense that were sufficient to get a license. For example, could you say, I have a fear that I will require self-defense in a time that I cannot predict? If that was allowed under this law, which is a little unclear, this law would be constitutional because anyone could have a need for self-defense, and therefore the general public is able to get a gun license or be permitted to carry a gun under that law.
Additionally, there's another complication in historical sources because the first open carry ban did not occur until 1872 in Texas. So before that time, concealed carry regulations, even very strict concealed carry regulations, would be more likely to be constitutional because open carry was still allowed and citizens still had a pathway in which to carry.
Second question, you went back and forth with the panel about the kinds of gun bearing restrictions that Heller seemed to countenance, but the respondent had an interesting point with that bears not just on what restrictions are permissible, but on the standard of review, because Heller mentioned a presumption of lawfulness, or that some laws are presumed to be lawful, which seems inconsistent with your argument that that strict scrutiny applies. How do you respond to that?
Heller mentioned 4 types of gun laws that are presumptively lawful: bans on felons carrying guns, bans on the mentally ill carrying guns, commercial sales laws, and sensitive places. This law is none of those, as this law takes the right to keep and bear arms for self-defense from the general public. So their argument for strict scrutiny, for intermediate scrutiny, on that basis is based on a misreading of Heller.
And the third and last question, thank you very much, goes to the compelling state interest point. So you've made the point that these laws are not necessary to achieve a compelling state interest and so on, but ordinarily we're fairly deferential to the decisions of legislatures and certainly of state legislatures in deciding what needs are compelling and what the factual support is for whether particular measures further those interests. Why shouldn't we defer to New York in this case?
Yes, Your Honor, that's for 2 reasons. First, because New York has not met their burden to demonstrate that this law actually achieves the compelling state interest of public safety that it sets out to. And second, because no government interest is so compelling that it allows the legislature to remove a core constitutional right, which is what the New York legislature has done in this case. Some sort of tailoring is required. New York has to demonstrate that there are no less restrictive means that they could use to create the same effect, which they have not done. Instead, they've created a blanket ban with a few exceptions, which turns a right into a privilege.
And DC v. Heller says specifically, The enshrinement of constitutional rights necessarily takes certain policy choices off the table. This policy choice needs to be taken off the table because it directly infringes on the ordinary citizen's right to bear arms for self-defense.
Thank you very much.
Thank you, Madam.
We pray that this court will reverse the judgment of the lower court, render a judgment declaring the New York statute unconstitutional, and enjoin enforcement of the statute against petitioners.
We'll now hear from Ms. Lawrence. Ready?
Madam Chief Justice, and may it please the court, the New York law should be upheld because proper cause requirements are constitutional. We would like to add a few matters to the facts of the case presented by petitioners. Most importantly, that the petitioners had the ability to appeal their permit decisions, and both did so. Both permit decisions were upheld by Justice Richard McNally in November of 2016 and 2018, respectively. New York State has a may-issue gun permit regime in which, for citizens to acquire license, two standards have to be met. First of all, they have to meet typical requirements in most states, such as not being mentally well as not being a felon. But second of all, they need to have an officer approve of their decision after they prove that they have a heightened need for self-defense above that of the general public in people in a similar situation. We'll now move into outline our case and then into a review standard. Our case has two prongs. First of all, the government's interest in promoting public safety, and second of all, federalism. In terms of the review standard, we believe that intermediate scrutiny should be applied for a few reasons. First of all is the historical backing. Historically, the Second Amendment has almost always had the government regulated in some manner. All the way back to the early 14th century, we cite orders by Edward I as the first example. And then throughout English common law, the founding of the country, and early American law, there are examples of regulations. Past that, we also see that, while not binding to the Supreme Court, appellate courts historically have applied intermediate scrutiny because of the incredibly important interest in promoting public safety. Cases such as Gold v. Morgan and Gachelski versus Gasecki show this.
Let me ask a question about that public safety rationale. I mean, so one of the main arguments in your briefs is that that the government protects public safety in public. And what if the government is failing to do that? Right? What if the government is failing in its obligation to keep the public safe, and then the state law is denying people the right to bear arms? I mean, so what should citizens do when the government is failing in its obligations?
Well, Your Honor, the Second Amendment was built to allow citizens to protect themselves, but if the law itself is viewed as failing, we believe that the legislative process is a more effective way to combat this. And there are two reasons. First of all, this is historically backed by precedent. Supreme Court precedent, such as Holder versus Humanitarian County, holds that issues such as public safety generally defer to the legislature. But second of all, we believe that this would go further, that broadening the Second Amendment right to this extent would actually further the danger in public safety. You can look to the recent New York subway attack as an example of this. In that situation, there were no armed citizens within the subway, which prevented crossfire and other citizens from being armed. However, we would contend that if the citizens within that smoke-filled subway car were armed with weapons, it would make the situation worse. We cite in our brief a multitude of studies and examples of how citizens being armed with weapons more often than not actually ends up in them harming innocent civilians rather than reducing crime altogether.
How should we think about those empirical studies, right? I mean, what role do empirical studies about public safety and carrying firearms today bear on how we should understand the Second Amendment? I mean, is that even relevant to the legal question for us?
Yes, Your Honor. It is relevant to the legality of this because we've seen in other cases such as Gold v. Morgan, the use of statistics. However, in the case where there are conflicting statistics, such as if there are statistics that could be used to support either side of the argument, in Gold v. Morgan, Antonin Scalia wrote that in this case, deference should be given to the legislature, to the states. So this goes to the second prong of our argument, which is federalism and that deference to the legislature to protect the states' rights to legislate on an issue such as this.
Before we move on to that, suppose that we agree with what your brief says, which is that right now it's better, it's safer to regulate guns, and the police do a good job of providing protection. But let's suppose things change. Let's suppose, for example, that the defund the police movement catches on and New York gets rid of its police officers altogether. Would this statute then become unconstitutional? I mean, in other words, I'm a little concerned, my concern just specifically is that if we rely on statistics and data taken at a particular time, then a law might be constitutional one moment and then unconstitutional at another moment and vice versa.
So, Your Honor, we would propose two responses to this. First of all, we do think that if that were the case and police were removed altogether, that would significantly alter the context of this law. We cite in our case the expectation of safety. In New York police, the policing power of New York State, protecting the safety, welfare, and health of the citizens, this falls under 3 of the 4 policing powers of the state. But also, Your Honor, we think that this law, as demonstrated, happens in a world where policing powers exist. So basically, the expectation of safety is relevant. So it's hard to speak exactly what would happen if police were removed, but we think it is incredibly relevant that police do exist in this world, and that does play an impact. And as Holder found, when there is a question of statistics, we believe that this prevails constitutionally, but on top of that, the use of statistics itself, almost always the Supreme Court has established, leads to deference to the legislative branch.
Now, so let me also ask about your argument that the government provides self-defense. Suppose the government decided to issue a newspaper and then said, look, you know, we really are wasting a lot of resources with private newspapers. The government can provide for the newspaper. We don't, I know there's a freedom of press and all, but you don't really need to have your own press because the government is providing a government-provided newspaper. And it's, you know, if that changes, then you can publish your own newspaper. But as long as the government has a newspaper, you don't need a right. I mean, wouldn't we say that that's ridiculous?
Your Honor, there's 2 reasons why I believe that that is a slightly different scenario than the Second Amendment. And first of all is the long history. Built within the Second Amendment, we believe, is this principle of government regulation. We cite a numerous amount of laws that hold this idea, and even proper cause requirements, which are over nearly 200 years old at this point. But then the second aspect is that the Second Amendment right and the exercise of the Second Amendment is not impeded entirely by this law. We, of course, see that petitioners are able to carry within their home, they're able to carry within their car under a separate licensing regime, and that the petitioners can also carry in off-country and back-road areas. So for 2 respects, the long history of Second Amendment regulations, as well as the fact that it's not impeded entirely, we think this is slightly separate. On top of that, I'd like to add that this is something brought up by the petitioners, but the First Amendment and Second Amendment should be viewed within slightly separate lenses. Of course, First Amendment examples of regulation, such as parade permits, show that there is a government ability to regulate. However, the Second Amendment impact on public safety is far greater than any negative impact that First Amendment exercise might have.
So you've made a lot of arguments about deference to state legislatures in terms of regulating firearms. Do you think this court was mistaken when it incorporated the Second Amendment?
No, Your Honor, we don't necessarily think the court was mistaken in this, given that a lot of fundamental rights at this point have been incorporated through selective incorporation, and this actually does give more latitude to the states because it's incorporated against the states. You're getting a level of individual right, but also a level of state power or separation instead of just having the fundamental rights at the national level.
And I'd also like to add to that this discretion, we do believe that McDonald correctly incorporated the Second Amendment, but it's also relevant to understand that discretion is important in the public safety implication. Of course, this was before Heller, but Prince v. U.S. showed that discretion in the Second Amendment has real impacts within individual communities. So this idea of discretion goes to an actual policy end, where it allows legislators to more closely tailor their needs to their cities. We note that many of the states that have regimes similar to New York are highly dense states that have, tight places such as subways that have a much greater public safety implication if weapons were to be within them.
Furthermore, in Prince v. U.S., we see that a local police commissioner or a chief law enforcement officer made the decision not to do background checks within his state. So the flip side of that, the 180 degrees, would be an officer in New York deciding to do background checks or to do this examination of proper cause. And we upheld it in Prince, so we should be able to uphold the opposite version of that in giving states discretion to legislate the way they see fit on gun rights, especially because states have different situations and they know best how to legislate on that.
Council, can I ask you about the Heller decision, and specifically Heller's description of sensitive places as being one area where gun regulation would be permitted? It kind of sounds to me like you're saying the great outdoors anywhere is a sensitive place. Doesn't that kind of negate this whole idea that sensitive places is an exception?
Well, Your Honor, I would respectfully say that we are contending that New York in general is not falling under the sensitive places. We contend that a sensitive place restriction is slightly different from the regulations we're offering here. So sensitive places, as you correctly state, in Heller were identified as singular, unique locations, such as a courtroom or a small school. Where in this situation, we're saying New York as a diverse state with multiple different cities, all have different regulations. So for example, bearing within all of New York City, this does not make all of New York City a sensitive place. However, it does uphold the safety of New York City. So respectfully, we would contend that this is an alternate in regulation form that can coexist with the sensitive places regulations that were set up in Heller.
I was interested in the argument in your brief about the link between the First Amendment and the Second Amendment. One of the arguments you make is that that public safety is important for people to exercise their First Amendment rights. So curtailing people's Second Amendment rights might allow them to better exercise their First Amendment rights. And I was trying to think if there were any other examples in which we have said a restriction on one fundamental right is necessary to further other fundamental rights. And I'm wondering if you have any examples of that type of reasoning, where we're sort of trading off fundamental rights against each other.
Well, Your Honor, I would say in general that's in many ways how fundamental rights work. And Second Amendment regulations in general function by regulating one fundamental right in terms of another fundamental right, the most fundamental right, the right to life. So we think in that respect, we see that Second Amendment regulations in that sense are regulating a fundamental right to protect another fundamental right. So we think that that's somewhat of an analogous situation, but once again, we'd like to state that the Second Amendment right is unique in the impacts that it has on public safety, where no other fundamental right is as dangerous to public safety or the exercise of other fundamental rights or rights in general as the Second Amendment can be.
Justice Schwartz, do you have any questions?
Yes, counsel. So I'm curious about the standard of review. You put a lot of weight on this phrase presumptively lawful in Heller. But as I look at the categories that Heller was talking about, the Heller court was talking about situations where the government is acting in its capacity as a proprietor, or where it's where it's licensing commercial activity, where ordinarily rational basis review applies, or where the people who are supposedly being denied their Second Amendment rights actually have due process protections before the rights are taken away. So given that those examples are distinguishable in those kinds of ways, how do you get to the point that the residue of the Second Amendment is still reviewed by something other than strict scrutiny?
Yes, Your Honor. So the reason we contend that we should use intermediate scrutiny is, as you mentioned, the incompatibility, and also because of the fact that it allows the state government a little bit more deference in legislating on the issue, and because the government's compelling state interest that is also necessary in the intermediate scrutiny standard is so strong, we believe that we easily clear that barrier. And if you don't buy that argument, however, and you would go with strict scrutiny, we believe again that the government's interest is so strong that it clears that barrier as well. And we would use the fact that the least restrictive means required under strict scrutiny is achieved, because the second prong is the least restrictive means to achieve the same compelling government interest. And the state of New York has found that there's no other way to achieve the same level of compelling government interest in public safety and saving lives as in using this specific regime the May issue regime.
And Your Honor, I'd also like to add one more thing to this point, which is that we're not saying Heller solely sets up intermediate scrutiny or presumptively lawful is the only reason why intermediate scrutiny exists. What we're contending is that because using a combination of this idea of presumptively lawful as well as this long history as Young v. Williams, over 700 history of common law and American law regulating the right to bear arms, we're contending that the government should have a higher latitude in regulating the Second Amendment. So while there are the presumptively lawful gun regulations set up in Heller are slightly different, we believe that it falls in line with this long history and precedent that the state has in regulating the Second Amendment right. And for that reason, we believe that there should be a less restrictive or a less restrictive standard of review than strict scrutiny applied to this case.
Your Honor, so my time is last. May I add something to the question? Thank you. Furthermore, we see that New York is unique in the differentiated areas of its state. So there are rural areas, but there's also a large urban area that we see in terms of other states that also have May issue regimes. There's a subway system. These areas have a need for the government to regulate more because the public safety risks are higher in that area, as we saw in that subway car. If someone in that subway car or multiple people in that subway car all had these permits, if this law was struck down, everyone in that subway car is at greater risk.
One final question about the historical evidence. So there are different categories of historical evidence that you and petitioners have referred to. The medieval evidence strikes me as hard to take out of its medieval feudal context, and some of the later evidence from state laws strikes me as hard to separate from, one is after the Bill of Rights, two is before incorporation, so hard to say how much weight to put on that. So what do you have that specifically rebuts the founding area view of the importance of individual self-defense as a fundamental right?
Your Honor, we have the 10th Amendment. We have the system of federalism that states that states also have the power to make sure that there's no tyranny, especially by the federal government as the founders intended. So we've seen this level of deference right from the founding era and let the states legislate to this, and in a way that doesn't fully extinguish the rights of their petitioners, but rather regulates them in that way. And furthermore, we have the historical context of this law being in place since 1911, and as gun issuing regimes go, this is relatively long-standing, been in place for about 111 years now. So we see that this has this historical context, this tradition of being in place in New York State specifically for quite a while.
Your Honor, we would also add that changes in society change the expectation of safety while also making weapons much more dangerous than they were at the time of the founding. As we know in a brief, multiple security, such as the police powers of the state and security systems, as well as guns getting more dangerous, all mean that the Second Amendment right, the need for self-defense in public is greatly reduced, while the impact that it has on public safety and chilling other fundamental rights is greatly increased. So for that reason, we think that this regime is in line with that founding historical era way of thinking.
Nothing more from me.
Thank you, and we pray that this court upholds the law.
Thank you.
Madam Chief Justice, Associate Justices, and may it please the court.
We respond to 3 arguments made by the respondents. First, that they conflate public safety with the right to self-defense. Second, they ignore the second prong of both intermediate and strict scrutiny, the tailoring requirement, And finally, that the Second Amendment is not a second-class right. First, respondents conflate the right to public safety with the right to self-defense. Self-defense is what the court has interpreted the Second Amendment to protect. And no matter how good the police system is, no matter how many resources the state has to protect citizens, that does not negate citizens' right to self-defense and to bear their own weapons for self-defense. and because the court in Heller indicated that handguns are the quintessential self-defense weapon, and that no matter what other avenues of self-defense citizens have available to them, handguns cannot be completely removed from the table. The New York statute is unconstitutional.
Looking at scrutiny, whether it's intermediate or strict scrutiny, we still hold that strict scrutiny is the proper level of review. And while we are not ready to concede that this law does actually increase public safety, we'd like to focus on the second prong, which is vastly more important, and that's the narrowly tailored prong. For strict scrutiny, the law must be necessary and narrowly tailored. This law is not necessary, nor is it narrowly tailored. More than 40 other states have completely different laws that do not infringe upon our Second Amendment rights, and it's not the Wild West there. Now, narrowly tailored, this law is not tailored. It takes the right away from all of the people, instead of targeting a specific group of people likely to go out and commit gun violence. When we look at intermediate scrutiny, the court last week in City of Austin v. Reagan National Advertising said that intermediate scrutiny is narrowly tailored with a significant government interest. Once again, this law is not tailored because it targets the people instead of a specific group of people likely to go out and commit gun violence.
So is it your view that any regulation that targeted all of the people would be unconstitutional?
Any regulation that took a right away from the majority of the people is most likely unconstitutional.
It's specifically the way that this particular law operates, that it forces the people to justify their need for self-defense in order to exercise the core constitutional right. So while there are and could be many different constitutional limits on the Second Amendment that do apply to all the people, such as a training requirement or a requirement to show proficiency, this specific law, because of the way it operates and the way it forces citizens to justify a Second Amendment right based on need, is unconstitutional. And similar laws also would be unconstitutional. Third and finally, the Second Amendment isn't a second-class right. So it should not be treated differently, as it is it has equal weight within the Constitution. Different constitutional rights do not decrease each other. So even though public safety may increase the First Amendment, this still does not give the government the power to remove individuals' Second Amendment rights.
It goes back to that quote from Heller: "The enshrinement of constitutional rights necessarily takes certain policy choices off the table." Once again, the First Amendment right is not a more important right than the Second Amendment right, or a right that you have all the time while you just have the Second Amendment right some of the time. You have both rights all of the time.
Council, can I just ask one point of clarification between your two briefs? In your footnotes, you both cite, both you and the respondents, cite studies which seem to contradict each other on the public safety question about open carry laws. What do we do with that, where they're contradictory studies? Respondents seem to suggest, well, if there turns on statistics like that, we really ought to just defer to the legislature.
Yes, Your Honor. It really comes down to that second prong of both strict scrutiny tests, that there is a tailoring requirement. So even if this law achieves the public interest, because this right is contained within the Second Amendment, because it's protected by the Second Amendment, it still does not allow the government to remove the right even for a compelling state interest. There is no state interest so compelling that it allows the state to remove a constitutional right.
As far as the studies go, as you mentioned, there is a very hard contrast. So at very best, this can't be proven whether this law actually achieves public safety. I see my time is up. May I finish?
Yes.
So because of the contradiction, we cannot know if this law truly does improve public safety. At worst, for respondents, we have a study specifically dealing with the Sullivan Act that came out in February that said this does not lead to a reduction in homicide. So the studies are inconclusive, if not showing that this law doesn't make a good difference on public safety.
We pray this court will grant the petitioner's appeal.
Thank you. Case is submitted.
Did you want to ask?
Oh, sorry, Justice Schwartz, do you have any?
No, nothing further.
Thank you, Your Honor.
All right.
All rise, court will be in recess for deliberations, and that means you guys leave. Thank you so much.
Should we leave these?
Yeah, you can leave your papers here, that's fine. Just wait outside the lobby. The mic's back on.
I have to say,
All right. Let me go back in. All right, one second, please.
Should we come back?
Yeah, sit where you're supposed to sit. I will stand in the spot for just a short. Schwartz, but there you go. You know where Bill Brooks is?
What?
Bill Brooks?
yes.
Amanda Schwartz, do it. Is that what you said? All right, congratulations to all of you. The prevailing team is petitioner, congratulations. And the best oralist is Campbell Collins, congratulations to you. We are so proud of you. This was a very hard decision, evenly matched. But we just want to say this was such a strong competition, and thank you so much. I know the judge would like some feedback to you, and just the congratulations to you very well.
Yeah, well, I guess I'll just start by saying, both teams did such a great job. You know, I read your briefs, that you're able to write such clear and logical and cogent briefs in high school is really a testament to all the hard work you've put into things. I see many briefs of varying quality in my job, and I can say you guys have really done a nice job in writing. And the oral arguments were also very strong. This is a very difficult thing to do, to stand up and to have learned so much about a particular case and about the law, and then to take all of our questions, you know, that are ranging over a whole number of cases and the history and empirical evidence and what are the implications of your view in one place for what might happen to the law in another place. I mean, these are all very, very difficult types of questions to grapple with, and you, all four of you did a really excellent job. So it was a hard decision. I think, Campbell, we just thought that you were especially good, at, being on your feet and pivoting and answering all of these different questions, and really grappling with some of the things that we threw at you. So congratulations on that.
Well, I'm just really impressed, and I don't think we have to say these are good briefs for people in high school. These are just good briefs, and your arguments were excellent. And, I'm just really impressed at how clearly all of you speak and how clearly all of you write and how responsive you were to our questions. And, when I think of good oral advocacy, I try to think of, different points that, I might convey. One is to be extraordinarily clear in your presentation and what it is you want to convey. And I thought, Archie, you were just really perfect in that response. Every sentence you said made sense. You were right. You were clear. I could understand everything that you were saying. And I thought, sorry, your name, Nicole. Nicole, another thing that I think is extremely important is working hard to get people to understand a difficult point. And I thought especially how you drew connections between different cases to try to explain these points. You were looking us in the eye and trying to get us to understand. I thought that was really very good. And Gabrielle, I thought you were very sensitive to the concerns of the bench, as opposed to necessarily just the direct question. Why are we asking that question? And I thought in a couple of places you took a step back after saying yes or no to explain what it was about your answer that would address our concerns. And Campbell, I thought you were very, very much on point on every topic. I thought your answers were very concise and extremely responsive. I think one rule at moot courts is that the judges tend to ask questions just to kind of press people and challenge them. And my law clerk might differ, but in actual cases, I try to reserve questions for things I don't know the answer to. And the reason I ask the question is I really don't know the answer, and I really want counsel to give me an answer, and if I don't get an answer, that's a really bad situation. And so I thought you were very responsive to those questions. me also just say one thing about your briefs. A lot of briefs we get are overly long and full of fluff. And your briefs were super concise on both sides. So this was a very impressive exercise. I want to congratulate all of you for getting to this stage.
Justice Schwartz?
So impressed with all four of you. I mean, if all of my advocates in front of me sounded like all of you, and if all the briefs were red light like these, that would be kind of a fine state of affairs, really, because you were all to the point. You were responsive to the questions. You were, you lined up your authority in a clear way and used it to support your arguments. And in the clear ways, you listened to the question and answered it without trying to fight the judge. It's really impressive, and you can all be very proud. You can all go on to, I'm sure, impressive things, having developed these foundations. It's harder for me to tell about the kind of oral presentation because I don't have that great view of any of you, but so I won't give anything individualized on that. One thing about the briefs I'll say is that I once lost a moot court myself because the judges didn't think that my team's brief kind of followed the style and formatting that they were used to. It didn't kind of look and feel like what a brief often looks like. I thought the petitioners did an especially good job of doing a mock-up of what a brief looks like. So they picked a good typeface. They did their blue booking very well. They did their spacing very well. They did their, the bolding of headings well, the nesting of subheadings well, the use of inline citations and quotations from the authorities was basically what you would expect from a solid brief. And so those kinds of physical touches combined with just an overall well-organized, tight, well-reasoned argument kind of put this brief over the top for me.
All right.
But congratulations.
And let me say a few words. I'm not behind the bench. I'll stand over here. I've now judged you, I think, for 4 rounds. I judged you at the semifinals. I judged you at the round of 8. Don't vote the final 4, so we'll get sued by the NCAA. The round 4, and I judge you here. And what I've seen is progress. One of the most important lessons you should take from this experience or any other is learning from your experiences to do better next time. You did improve from the first round to the second round, the third round to up here. I saw the improvement. I saw questions that I asked you 3 months ago that Justice Maggs and Justice Stroud asked you, and you nailed in the first shot because you've been there, right? I've seen how you improve your rapport from one partner to the next, how you do this very smooth handoff. It's not usual, law schools don't do this, but I think they have a very good smooth rapport to hand off one to the next. I've seen your demeanor, where you stand at attention, you keep your hands on the podium, you keep your voice flat, right? You don't get excited, you don't get emotional, right? You give a very a sober delivery. And the 4 of you have comported yourselves as well as any law student who ever seen a moot court competition. You could walk into Georgetown Law Center 5 feet away tomorrow and go compete in a moot court competition, right? You have such bright futures ahead of you. I am so excited to see where you'll be in 4 or 5 years. I hope you come back and tell me. But more importantly, the reason why I do this, why the Harlan Institute believes in this mission, is we have this crisis of civic affairs. Students don't know about the Constitution. They don't know about the court. They simply just don't know about these things. They think they're taught as you're wrong. You are the exception to that rule. You are having eloquent, passionate, informed debates about gun control, not an easy issue to talk about. And you brought to it rigor and discipline and candor. When your position's not strong, you told the judges, then you pivoted to a strength. So I hope that the 4 of you and all the other dozens and dozens of people in this competition can bring with them this sort of insight and passion for the law and just make our republic that much stronger. future. And this is one of the highlights of my year. So I'm so thrilled to be back here with my good friends on the bench and these brilliant young minds. And I hope next year we'll have even stronger competitions to play again. Thank you so much. I want to give the four of you a chance to ask our bench. You don't get appellate judges and very often to ask questions. Maybe you do, I don't know. But these are judges who have also, well, at least Justice Rao and Mags, former professors, and Justice Schwartz was in private practice for many years. Questions that you might have, and I'm sure they'll be happy to answer them.
I have a question. I'm curious your opinion just on the case. Like, don't decide based on arguments necessarily, but I want to know what you think about the New York law and whether it's constitutional or not.
It's one question they want to answer. Judges can't answer questions of pending matters, so so maybe revise your question, maybe tweak it.
Also because we could get cases that are of a similar nature, possibly, so.
Yes, the one question you can't answer.
Right, so unfortunately.
Well, I'll answer it. How about that? Which might not be that different. So look, I'm actually grateful the court hasn't decided the case yet. A couple of years ago, we did a case, and the Supreme Court decided a week before a championship round, which made it, that was yours, right? Which made it very hard to actually do this. I suspect the court will declare the New York law unconstitutional. I don't think that's much of a surprise. I think they're going to avoid any sort of discussion of scrutiny, because if they actually say strict scrutiny, like the position you were pushing, that would throw into jeopardy a wide range of gun laws. So more likely they'll say, oh, it's text and history. If you look at Judge Kavanaugh's opinion in the case of Appellate 2, which you're all familiar with, he had a sort of text and history approach. I think that's what it works. I don't want to ask these two people for their opinions, but that's just my off the cuff. So there we go. There's one question you could ask. Other questions that they can answer. Arjun?
So this is, I guess, sort of a general question about law. I'm not sure how much it comes up being the judge, but representing perhaps positions you don't hold, or if there are positions that you've passed judgment on that perhaps go against your personal beliefs, how do you feel about sort of your relationship with like your personal beliefs and doing what the law says or doing what you think is required by the law?
That's a good question.
I think it's very important to separate the two. And I've reached some decisions that don't really sit well with me, that I feel that are compelled by precedent or compelled by the text of the statute. And if I had the chance to write the statute differently, I would do so. I think one of the best things to do is when you confront a case and you feel that you might be biased in one sense, is to put that bias out on the table. Tell your law clerks or others, my gut reaction is this, but let's put that aside. And that way, when you're thinking about the case and discussing it, you can always say, wait a minute, am I going back to my gut reaction, or am I actually just deciding this based on what the statute says, what precedent says, or am I somehow letting something else interfere with my decision? Now, of course, best as a judge, when you're a lawyer, it almost works in the opposite way, which is that you have to recognize that your gut reaction might make you overconfident, and that you might not think highly of the opposing side's views. For example, suppose you really do agree with your client, you want your client to win, you might dismiss the other side's views. And what I think one of the best things to always do is put yourself in the position of the other side and think, what would they argue? If I were representing them and I had to attack this position, what would be the very best way to do it? And I think that's always a good way to keep yourself honest.
I agree with what Judge Mag said. I would just add, I think you're probably not doing your job as a judge if you don't feel uncomfortable with some of the results that you reach, because it would be unusual that the law always turns out in the way that you think it should, because that's not our job. So in some ways, I'm, if I find that the outcome is one that maybe doesn't fit with my personal beliefs of what the law should be, I guess I'm not overly worried, because I know that's not my role. I think it's particularly important, however, for judges when the outcome lines up with what your gut instinct is or what your intuition is. That's when you have to be particularly careful, that you are not just following your instincts or your preferences. So I think in some ways those cases are harder, and I know I will, maybe double, triple check myself to make sure I'm really following the law in those cases. In some ways, I think those are the harder ones.
Justice Schwartz?
When I was clerking, I had this trick that I did where when I thought that I was leaning to make a recommendation on a case, I would try to come up with some kind of, and where I thought the outcome was pleasing for some reason. I would try to come up with some scenario in my head where the facts would be similar and the applicable law would be similar, but the outcome would be displeasing to me in some way. I would kind of think through that hypothetical and how I would reason through that as a check on doing something that on just getting a recommendation to my judge that I thought I would like the outcome on, and that I thought at the time at least kind of helped me maintain some objectivity about the case that was actually sitting in front of me.
I'll give one small anecdote from Justice Scalia. This is a famous story. In the late 1980s, was a case called Texas versus Johnson on the flag burning. Maybe you've heard the story. You have to stop me. Hey, come up. Hello. And so Justice Scalia, you might imagine, was not a fan of flag burning. But he was a fan of the First Amendment, and he reached a decision that said a Texas prosecution flag burning is unconstitutional. And there's this great story where he said, if it was up to me, if I was king, I'll paraphrase, every sandal-wearing hippie would go to jail for burning a flag. But Scalia said, I'm not king. And Scalia would use this anecdote to illustrate sometimes when this is Justice Rouse's point, when your priors conflict with the law, when the law goes one way and your beliefs go the other way, that means you're kind of doing your job. And I think that's one way to sort of check it. If you're always agreeing with your legal positions, that might be a sign that you have to reevaluate your legal position, that maybe it's being influenced by your positions. But when you're a lawyer in private practice, I think it's a different question. You often have to take a position you disagree with because that's your client's position. And you often have to put that, your preferences aside, or maybe choose a different line of work, right? If you can't put your preferences aside, maybe you're not the line of work. If you're a judge, you have to do it. When you're an attorney, you have to follow your client where the law leads. And Nicole was patiently waiting.
So my question is around judicial activism. I think recently, I guess in kind of the political zeitgeist, it's become more of a politicized term than one that describes legal decisions anymore. I think both sides have started to use it against decisions they don't like rather than what it was initially intended to use. So I guess my question is, what's your stance on reframing the way we use judicial activism? Should we stop using that term as it become non-meaningful? Should we just look at cases based on their merits or the issue they look at specifically, or just continue with that term and maybe reframe it a different way?
Schwartz.
That's a thought-provoking question. I need a moment to think it through.
Nicole, I agree with you, which is I don't think it's a useful term because it can mean anything to anybody. But your second alternative, which is, look, if the judge reached a decision and gave these reasons, refute them if you don't like them. That's what Voltaire said. You don't like a book, refute it. And I think it's would be much more persuasive. That the Supreme Court decides something and you disagree with the outcome. Say what the arguments the Supreme Court made were, and say why you disagree with them. And we don't really need a label. We can have arguments. And so I think your suggestion that we get rid of the term and just respond to the arguments seems more honest.
I think, just to follow up on what Judge Mack said, I think it is very helpful to have a richer discussion about what courts are supposed to be doing, right? So judicial activism is a term that doesn't really encapsulate, doesn't have any one particular meaning. But I do think it's important for Americans as part of their civic education, and what all of you are doing just by participating in this competition, to be thinking about what is the role of the courts in our constitutional democracy? What are judges supposed to be doing? And how is that activity different from the legislative power and the executive power? And I think having, having that type of discussion, what is it that courts are supposed to be doing, is perhaps a more interesting and important way of thinking about why some decisions might be, right or wrong.
Justice Schwartz?
I'll actually second Judge Rao on that. I mean, I think that there is a legitimate distinction between decisions that one might not like as a matter of outcome and decisions that where the judge is following where the judge is actually following some kind of method that's questionable. So really the question about whether it's useful to talk about judicial activism comes down to questions about what the proper criteria are for good judging, which is another way of putting Judge Rao's point about the importance of awareness about the court. Because if you have people who say who cry judicial activism whenever there's a decision that they don't like, what you have, and this is pretty widespread in commentary about the courts, you have corruption from kind of all ends of the political spectrum of what the public thinks the courts ought to be doing. So I'm not necessarily opposed to the idea of calling hypothetically a poorly reasoned decision activist because it pursues an outcome rather than pursuing a correct methodological approach. But the problem is that people use judicial activism in a way that describes outcomes rather than describing methodologies. And that the result of that kind of infects the public mind about what, in their views, about what a court ought to be doing and what its methods ought to be.
I think another related topic to this question is there's a lot of talk now about judicial legitimacy and what it means for the courts to be legitimate. And I think that is another question that just also kind of pushes one back another step to think, what is it that courts are supposed to be doing? What makes it then legitimate? And I think there are many different ways in which that's being talked about today. And I think that's something to also be thinking about as part of the public debate.
Questions from petitioners? Campbell, Gabrielle?
Dear, I've been put on the spot a little bit. Chief Justice Rao, if I'm not mistaken, I believe you went to the University of Chicago Law School. As someone who's rather fond of the University of Chicago, I'd love to hear about what that was like.
Well, I'm a big fan of my alma mater. Chicago has really a remarkable law faculty that's not only, does wonderful research, but it has a very strong teaching culture. So the professors I had, all 3 years were not only amazing, distinguished scholars, but they also put a lot of effort into their classroom preparation. And so I just feel like I had a very thorough and deep education in my 3 years there. I think that they rewired my brain to think like a lawyer in a really meaningful way. And so I thought it was great. If I had to choose it again, I would go back.
Having had the privilege of going there about 10 years more recently than Justice Rao.
Not running in here, Judge Schwartz.
Same sentiments, exactly. Wonderful place.
I went to George Mason Law School, and Professor Rao was my professor. I was also very, very fortunate. So, but Chicago is a special place. Any questions?
I'm gonna think of some later and regret that I didn't ask them, but I don't have anything right now.
Yeah, Nicole?
One more. So I wanted to ask you guys about personal precedent. This is something that I've seen a lot more recently, which is judges having their own personal precedent in the way that they've decided certain cases or legal issues. And in addition to looking at the facts of the case or the legal issue at hand, they'll abide by the previous ways they've looked at that legal issue and are scared to overturn that to be personally or inherently contradictory. And I wanted to know what your thoughts on the effect of that on the judicial process, how to consider that. Or is it expanding more now as we move, like legal scholarship, or the longer you've been on the bench, you have more opinions like that?
You know, I don't think it's anything new. So for example, the Supreme Court upheld the death penalty as being constitutional, and Justice Brennan and Justice Marshall in hundreds of cases said, adhering to our views that it's unconstitutional, we still say it's unconstitutional.
Yeah.
So I don't think it's a new phenomenon. You know, I think courts would cease to function if everybody refused to follow precedents that they disagreed with. I suppose at certain extremes that maybe you just simply say, look, I cannot sign on to that because I just fundamentally disagree with all of this, everything behind it. But if you just think about it, if all of a sudden precedent didn't mean anything to any of the judges and they just continued to decide everything de novo, how would any litigant know what was what? How would you have a court? It's all like individual judges. So I don't think it's new. I'm not saying you should never adhere to your views, but I do think it is it's certainly a practice that causes great concern to me.
You referred to Richard Ray's new article on personal precedent?
Yeah.
I knew it. They read all of your articles.
I know.
Yeah.
It's interesting.
Yeah, so Richard Ray is a scholar at UVA now, and he's a brilliant scholar, but I think it's an important point where judges sort of peg themselves in and they feel the need to be consistent with what they previously said. So even on top of stare decisis, it's personal decisis, right? Please say personal right, that's your line confusing. It's a personal restriction. I think the Marshall Brennan example is a good one. Even the Supreme Court, Justice Barrett said, we're not going to use a shadow docket. I think she locked herself in on that one. And she's been pretty consistent denying every single injunction since. So I think judges, they do.
I guess one way to think about it, it's hard to know if judges are following personal precedent, whether that's locking them into a position they don't like, or if they have, or the other way to think about it is that they've spent a lot of time thinking about a particular issue and they think it's important, and so they reiterate that point in some hope maybe that the law will change. I mean, I think that's more true for Supreme Court justices. I don't think you see this issue as much in the lower courts, but I don't know that it is necessarily something negative, right? If a justice has formed a very firm view about the law, I'm not sure that it's necessarily a negative.
Nicole, one thing you can sometimes see when you read an opinion is if the opinion says proposition of law, then a citation, versus it says this court has held, and then they have the proposition of the citation. When they say this court has held, that may be like, I'm not saying I agree with it. This court has held. It's subtle, but I see it all the time when I read opinions.
I do that too.
Everybody does it.
We have said.
I don't agree. I put this court.
One thing I'm sorry, I don't mean to talk over people. One thing I'll add as a trial court judge is that you kind of need to distinguish when you think about personal precedent between different courts and the different roles that precedent play on those courts. I mean, at the Supreme Court, you have precedents, but they're all subject to stare decisis, and they could all be theoretically reconsidered. So you can have a justice who kind of wants to make a sustained argument over time that a precedent should be reconsidered, and we can hear his view. On an intermediate court, it's all precedent. There's the option of taking certain things on bonk to get circuit precedent changed, but ordinarily once the court says something, that's the way it is. And so the judge's individual views of personal precedent, no matter all that much. On the trial court, obviously, I'm bound by everything that my Circuit Court of Appeals has said and everything that the Supreme Court has said. But within that, there's still different strands of thought among the current and former judges on my court. And there have been a number of occasions just in the 16 months or so I've been on the bench that I've kind of developed my own view on some particular thing, and I've had the opportunity to reapply that in more than one case because the Federal Circuit upstairs hasn't weighed in yet. So for me, I mean, personal precedent is just a function of me trying to get it right the first time, and then sticking with that view until the litigant gives me something different.
All right, any other questions? All right, I think we are at a close, so I will say the court is now in recess. If you come up, we'll take some pictures. You can shake the judge's hand, but congratulations, everybody. Judge Rao. You have 2 minutes for pictures? Yes. You have a real job.